So at the Supreme Court's recent 8-1 decision, the New York concealed carry case was then remanded back down to the lower court for reconsideration in light of that decision. So we need to talk about what is now happening in this critical case. Now, really quick before we jump into this video, I want to ask you guys for a favor. If you like this video, if you support the channel, please just like the video, comment, subscribe. Commenting and subscribing really does help the channel to grow, for these videos to get out to more people. It fuels Al Gore's rhythm and just again really helps this to get out to more people. And also I want to thank one of the main supporters of this channel, which is Kershaw Knives. A lot of you guys know that Kershaw has been supporting the channel for a really long time. Kershaw was one of the first companies that jumped on board to support this 2A channel, and so I want to thank them for all of their support. And if you guys go to their website and you order using the code ARMED40, you can get 40% off of your order as long as it's the MSRP price of that product. Now, as I mentioned in the intro, in this video, we will be discussing how this issue of concealed carry bans in the state of New York are now once again up for debate, up for consideration in the Second Circuit because of the Supreme Court's recent 8-1 decision in a critical 2A case called Rahimi. After Rahimi, this New York concealed carry case was then remanded by the Supreme Court back down to the lower court for a new decision in light of what the Supreme Court said in Rahimi. You may recall that recently 5 cases had expedited hearings before the Second Circuit Court of Appeals because of the recent warnings that the Supreme Court issued to the Second Circuit. These 5 cases challenged New York's new Concealed Carry Improvement Act, also known as the CCIA. That New York law created a hyper-restrictive concealed carry law that was in direct response and in direct defiance to what the Supreme Court said in Bruin. New York and the Second Circuit continued to defy that express decision, but after the Supreme Court's Rahimi decision and the remand of the Antonyuk case, the Second Circuit has opened this case back up for review. The Second Circuit also then dismissed review of 4 other of the cases that were consolidated, and they said that they don't have to address those, they don't have to re-review those decisions, because the Supreme Court only remanded review in this one case, Antonyuk. And now the parties have filed their supplemental briefs arguing what impact the Rahimi decision will have on this New York Concealed Carry Improvement Act restriction and how Rahimi would change or potentially modify the decision that the Second Circuit issued before. Now, this issue of concealed carry laws in the state of New York have been a long battle and probably should have ended after Bruin, but like I mentioned, after the Bruin decision and after the Supreme Court struck down New York's original May issue CCW licensing scheme, the state of New York and the governor there decided to engage in direct defiance to the Supreme Court and pass the Concealed Carry Improvement Act just 8 days after the Bruin decision. Now, this law was challenged in multiple cases and in multiple district courts, and originally in some of those cases, preliminary injunctions were granted halting some aspects of the CCIA law. However, the state of New York then appealed those decisions, those preliminary injunctions, up to the Second Circuit Court of Appeals, who then granted some blanket stays on all of those decisions. Now, in response, you had some organizations like GOA in the Antonyuk case, who then went to the Supreme Court on an emergency basis, seeking emergency intervention from the Supreme Court. Now, the Supreme Court on review initially decided to not get engaged in that, did not want to grant those emergency applications. But even in denying those emergency applications, you did have some statements from some of the justices like Alito, who did warn the Second Circuit that they can't drag their feet on these issues, that they have to address the CCIA law in light of Bruin, and they need to hold hearings in these cases. Then soon after that, the Second Circuit decided to hold expedited hearings in these cases, and then the Second Circuit ruled in 5 of the CCIA lawsuits. Now, in their decision, the Second Circuit distinguished Bruin as an exceptional case. Therefore, the Second Circuit vacated much of the district court's preliminary injunction, finding virtually all of the CCIA to be facially constitutional under the Second Amendment, even in light of what the Supreme Court said in Bruin. Now, in response to that ruling, GOA then filed a second petition for an emergency Supreme Court intervention, and although this case was still in an interlocutory posture, which means it wasn't on a final merits, it was kind of in this in-between phase, the Supreme Court did decide to GVR, which means they granted, vacated, and remanded this case back down to the Second Circuit in light of what they just said in Rahimi, which was that 8-1 decision. In the Rahimi decision, the majority of the court found that the domestic violence restraining order of federal laws did not violate the Second Amendment because they believed there were traditions and principles that pointed to the constitutionality of that federal law. Now, after the Supreme Court GVR'd the Antonyuk case back down to the Second Circuit opened this case back up and then requested supplemental briefs to be issued to them on how essentially rahimi impacts the outcome of these CCIA lawsuits. Originally, the Second Circuit had also requested for some briefs in all 5 of the consolidated cases. They were going to review all of these, but then they sent out a new order saying that no, the Supreme Court had only remanded the Antonyuk case back down to them in light of rahimi, so that's the only case they're going to address. And now we just received the first opening briefs, the first supplemental briefs on what impact the rahimi decision should have on the outcome of this case. Now, in the Antonyuk and the GOA briefs, they state that the U.S. versus rahimi case confirms that this court's singular reliance on a mid to late 19th century history was improper. Likewise, rahimi rejects outright that a person may be disarmed simply because he is not responsible. Next, rahimi confirms the text, history, and tradition framework from DC versus Heller and Bruin undermine this court's view that less exceptional cases permit a more nuanced approach. Indeed, the rahimi court made clear that it was following Bruin's methodology to the letter. Finally, the rahimi case demonstrates that this court must wrestle with the complete history of good moral character, including its uniquely racist pedigree, not just a sanitized version from the late 1800s. For these reasons, rahimi confirms that the district court's preliminary injunction challenged on appeal should be affirmed. So there are some main takeaways from the rahimi decision that are now being presented in this brief, essentially against New York's concealed carry law, and also the Second Circuit's prior decision, essentially arguing that also under rahimi, it is very clear that the Second Circuit just got their prior decision wrong. First, rahimi rejected the responsible person approach. The people mentioned in the text of the Second Amendment has been found to be all people, not just a vague responsible person standard that really the government can define as whatever they want. Here, the concealed carry law in New York tries to disqualify people from exercising their two-way rights based on a finding that maybe they are not of good moral character, that you have to show you are of good moral character. Essentially, law enforcement also has a ton of discretion to determine who is a responsible person, who is not a responsible person, who has that moral character to then get that permit. And that type of standard, that type of responsible person analysis was rejected in rahimi, and that also means that the CCIA's good moral character standard should also be struck down. Now, the second significant argument being made in this brief is that the rahimi case used the Bruin analysis to reach its decision, and they used the text, history, and tradition standard in that analysis, and that type of analysis is clearly controlling. That is the precedent when you're looking at two-way cases. However, the Second Circuit, prior when they looked at this Antonyuk case, tried to say that Bruin only applied in exceptional cases. And they said that this issue dealing with the CCIA was not an exceptional case, therefore they did not need to apply the Bruin approach. They didn't have to apply the Bruin analysis. Instead, they could use a more nuanced approach. But when you look at rahimi and that 8-1 decision from the Supreme Court, clearly they stuck to the text, history, and tradition standard. And so that is the type of analysis that should be used. The Second Circuit used the wrong analysis prior, and therefore their prior decision must be reversed under this new, decision that is issued in rahimi, once again reaffirming that that is the proper analysis, which is text, history, and tradition. So this is a very important battle, especially after the Supreme Court recently issued that rahimi decision and then decided to GVR this Antonyuk case back down to the Second Circuit. This, of course, will have huge ramifications for concealed carry laws in states, who have these hyper-restrictive concealed carry laws like New York, New Jersey, California, and others. Antonyuk is one of those cases that we want to fall out in our favor, because if it doesn't, then you're going to see citations in circuit courts like the Ninth Circuit and others pointing to Antonyuk, pointing to the decision out of the Second Circuit saying, we are just going to follow what the Second Circuit said. So that's what's going on in the New York concealed carry case after the Supreme Court decided to grant, vacate, and remand it after the rahimi decision. As we get more information, I will let you guys know. Also, if you like this video and you'd like to support the channel, one of the best ways to do that is to like, comment, and subscribe. All those things help to fuel the algorithm, and it signals to YouTube that you guys see value in these videos and in this type of two-way news. But as always, thank you all for watching. Don't forget to like and subscribe. And never forget, this nation was built by armed scholars, and this nation will be maintained by armed scholars.